In this module, we're going to be covering contracts, an overview of sorts. So when you think of a contract, I don't want you necessarily just to go to the idea you have that attorneys were involved, they drafted it back and forth, they tracked changes, and then it was executed by CEOs. It's called an agreement or it's called a contract, and everyone signed it, and maybe there's even some certificates by some of the officers of the corporation. Maybe that's a contract. But a contract exists anytime all of the contractual elements exist. And so what I want you to think of instead of the words contract or agreement, I want you to think of the word promise, promises. So some promises are not enforceable in a court of law. We may make a friendly promise, and certainly maybe we should keep that promise, but you're not going to be able to go to court and get the law involved and have a court order or a judgment saying that this promise that you made to pick up your sister from school is enforceable. Now, maybe if you were an Uber driver, it might be, but some promises are just that. They're just promises. But a contract is a promise or a set of promises for the breach of which the law provides a remedy. That's sort of a threshold burden. If you have the kind of promise or a set of promises that the law will actually come in and provide a remedy for it, that's going to be the contractual level of promise. So when we're talking about promises, we also need to talk about the people involved, the promisor and the promisee. Now, I don't want you to gloss over this. Promisor is the person who makes a promise. Promisee is the person to whom the promise is made. You're also going to see offeror and offeree, and it's very important that you get this locked in, that you're never confused. When you see the word or you hear the word promisor, you know that's the person who made the promise. When you see the word promisee or you hear the word promisee, you know immediately that's the person to whom the promise is made. That will help you when you're encountering problems, essay questions, other multiple choice questions. You need to keep the people, the actors here, straight. So promisee is the person to whom the promise is made. Promisor is the person who's making the promise. There are essentially two sources for contract law. One is the common law, and it governs essentially all contracts, except for the ones that statutory law, or the UCC, governs. The UCC covers the sale of goods and the lease of goods. Everything else essentially is common law. And we're going to pay particular attention to common law contracts in this course. And I think that's the right way to approach it too. First, it's complicated. You have to learn all the elements, how contracts are formed, what an offer is, what acceptance is, what legal capacity is, for instance. And then when you have common law contracts down, then when you start studying the UCC, you'll be making minor adjustments, and you'll already have a framework, and you'll know, well, if this is UCC, this one particular element is a little different. And that's probably the best way to approach contract law in total. So the definition of a contract, here it is. It's an agreement that can be enforced in court. An agreement that can be enforced in court. It's going to be formed by two parties at least, each of whom agrees to perform or refrain from performing some act now or in the future. So every contract involves at least two parties. The first is the offeror. That's the person who makes the offer. And then the offeree. That's the person to whom the offer was made. Offeror, offeree. So there are four elements of a valid contract. And a contract will exist any time all of these four requirements are met. The four elements are agreement, consideration, contractual capacity, and legality. So in order to form a contract, you must have an agreement. Well, how do you prove that? As you're reading through the text, you'll see that you prove an agreement by showing that there was an offer made with serious intent to be bound. The terms were definite enough to hold both parties accountable, and then that offer was communicated. You can't have an offer just in your mind as an idea in your head. You actually have to communicate it. And then acceptance for common law contracts has to be a mirror image. If you accept the terms, but you change one term slightly, well, that's great, but that's no longer acceptance. That's a new offer. We call that a counteroffer. You have essentially rejected the original offer. And it's fine. It happens every day. But you have to accept a mirror image, at least in common law contracts. Consideration doesn't mean being kind, not in the context of contract law. Consideration means something more like money. In order to show that you have consideration for contract law, you have to show that there was bargained for exchange and that the consideration had legally sufficient value. So in some sense, a penny can be legally sufficient value. But something like past consideration, or having a pre-existing duty to do the thing anyway, or illusory promises, those don't add up to legally sufficient value. Those are the three things that you'll learn about that you need to know about. Bargain for exchange, we're generally going to sort of assume that's the case unless there is fraud, or maybe there was undue influence or duress, or certain kinds of mistakes were at play. And then contractual capacity, think about someone who's under the age of 18. Someone who is under the age of 18 does not have contractual capacity. They might be able to form a voidable contract, but they cannot form a full-fledged valid contract. That is, they still have the right to disaffirm that contract up until the age of majority, and in some cases, even a reasonable amount of time after majority or reaching the age of majority. There are also people, no matter what their age, that don't have contractual capacity. And that would be someone maybe with a mental incapacity or a mental illness. It could be someone for a brief period of time who is so drunk and so intoxicated that they don't have mental capacity. And there are two kinds of people then, or two classifications. One would be those who have been adjudicated in a court of law as lacking mental capacity or contractual capacity. Typically, there's a guardian appointed at that point. Those people who have been adjudicated in a court of law, they cannot form any kind of contract. They are void from the beginning, ab initio. And then there are all the rest. So someone who's intoxicated is not going to be adjudicated because they're going to be sober within a number of hours. Someone who is in a car accident might be adjudicated. They're injured so badly that they really don't have the requisite mental capacity to be held accountable for their promises, the acceptance, or their offers. Finally, legality. You cannot have a valid contract in a murder for hire contract, or an assassination contract, or for a contract to sell cocaine. It's not legal to do so, and you can even pay attorneys large sums of money to draft purported contracts. They will not be contracts. They're void ab initio. There's some other kinds of things that are not quite criminal, but they're so far against public policy that we just don't enforce them. So if you have a contract to hire some employees, but the contract is to be discriminatory on the basis of race, those will not be enforced. So we have agreement, consideration, contractual capacity, and legality. Voluntary consent, I mentioned fraud, I mentioned undue influence and duress, and some kinds of mistakes here. The reason why you don't have bargain for exchange is because those things exist. Those things demonstrate a lack of voluntary consent. And if you don't have a voluntary consent, your contract, at least what you're purporting to be a contract, is going to be unenforceable. And then the last thing to consider in these requirements, your textbook says this is a defense to the enforceability of a contract, and that's a fine way to think about form. That is, they're a writing requirement. That's fine, but I think that if the statute of frauds applies and that certain kind of contracts have to be in writing if they're not, I think it's helpful for students to think about that as sort of an element that must be met. But either way you think about it, if it's supposed to be in writing and the law requires it be in writing to be enforceable, and it's not, well, then it's not enforceable. So an example of one of those kinds of contracts would be contracts that pertain to real estate. If you're going to buy and sell a house, in order for that to be enforceable, it's got to be in writing. Now, there's 4 Boolean type modifying terms. 3 of them are here. Bilateral versus unilateral, formal versus informal, and then express versus implied. And these are segregated out from the last couplet, which is executed in executory, because these have to do with formation of contract. So imagine I said, I promise to pay you $500 if you mow my lawn by 5 p.m. on Friday. That is a unilateral offer. because the only way you can accept that offer is by actually performing. That is, you have to mow my lawn. Once you fully mow my lawn, you have accepted that contract and I owe you $500. But listen to this one. I promise to pay you $500 if you promise to mow my lawn by 5 o'clock on Friday. In that case, I'm promising to pay you $500 in exchange for you promising to mow my lawn. In that case, the moment you say, oh, yes, of course, yes, I agree, I promise. The moment you accept, we have a contract. Now, why does it make a difference? Well, first of all, the offeror has control. I get to decide if I'm making the offer, if it's unilateral or bilateral. If I say, I promise to pay you $500 if you mow my lawn by 5 o'clock, that's unilateral because the only way you can accept it is by performing. And you don't perform, okay, no harm, no foul. You never accepted the contract. I can't do anything about it. But what if I said, I promise to pay you $500 if you promise to mow my lawn by 5 o'clock on Friday? Once you accept, we have a contract right then. And if you do not mow my lawn by 5 o'clock on Friday, I can sue you for breach of contract. So it does matter. Formal versus informal. Well, some contracts just require formality. For instance, real estate contracts, they must be in writing. If they're not enforceable. But you can have other contracts that are very informal. And they can be formed either way. Some require the formality and some don't. But even if a contract doesn't require formality, you can put it in writing, and you probably should. Finally is express versus implied. So imagine you go to Target and you buy a Snickers bar. That transaction has an underlying contract, and it is both express and implied. It's kind of a mix. Express insofar as there was likely a planogram label right in front of the Snickers bars box on the shelf that told you precisely how much it was going to cost. And you went to the cashier, and that's how much it rung up for, and you gave them the cash, and they gave you the candy bar in a sack, and they also gave you a receipt. That is part express and part implied. The implied is the conduct of the parties. You probably didn't engage in negotiations with the cashier. You probably just put it on the conveyor belt and paid for it. So that would be implied. Your actions implied that you accepted the offer of however much money it was for the Snickers bar, and everything is fine and dandy, and there is a contract, and you could sue under it. The last couplet has to do with after the contract has been formed. So you're assuming a contract. And either a unilateral or a bilateral contract can be executory or executed. So if I say, I promise to pay you $500 if you mow my lawn by 5 o'clock on Friday, and then you do mow my lawn by 4 o'clock on Friday, that is an executory contract at that point because you have accepted by performance. Until I actually pay you the $500, though, it's going to remain executory. Once I pay you the $500, it's executed. So the executory contract or the executed contract, it's not really that difficult to understand. If the contract has been finally and fully performed by all parties, it's executed. If there's something left remaining, it's still executory. There's some further classifications here: valid contract and void contract. A valid contract is sort of technically redundant. It's like saying an unmarried bachelor. Well, that's redundant because a bachelor by definition is unmarried. So if you say this is an unmarried bachelor, you're just being redundant. That's the same with a valid contract. A valid contract is a valid contract. In order for you to say that a contract exists, it's going to be valid. And a void contract is the opposite. It's like saying he's a married bachelor. Well, that doesn't even make sense. You can't be a married, unmarried man. That doesn't make sense at all. It's nonsensical and it's contradictory. Same thing with a void contract. A void contract is not a contract at all. But using that terminology is helpful because in the court system, or even as lawyers or those people who are business movers and shakers, a lot of time we're talking about a purported or an alleged contract. So we're really saying this alleged contract is actually valid. Or we're saying this alleged contract is actually no contract at all. So one step deeper An enforceable contract is sort of the best of all the worlds. It is a full-fledged valid contract. An unenforceable contract that's valid otherwise is something like this. Let's assume you have a perfectly enforceable contract and someone breaches it and you wait for 4 years and 1 day. Well, assume with me that the statute of limitations is 4 years. Well, you've blown the statute of limitations. It's a perfectly good contract if you would have filed suit 3 days earlier, but now that you waited until the statute of limitations has run, it's unenforceable. So that's the unenforceable contract that's otherwise valid. It's unenforceable for other reasons. And then the voidable contract. This is the kind of contract that a minor can create. A minor creates a voidable contract, and it can behave just like a normal contract. But the minor also has an opportunity, a privilege, a right to disaffirm that contract. And if the minor disaffirms that contract, it immediately becomes void. And if a minor decides after reaching the age of majority that she really likes the contract, she can affirm it, she can ratify it, and it becomes valid. And there's nothing more she can do about it once she reaches the age of majority. So those are the classifications in an overview setting of contracts. And I hope as you're reading through the next chapters that will come in the next modules, you will see that we're going to do a deep dive on the first element of agreement, a deep dive on the element of consideration, and a whole chapter over contractual capacity and legality as well, so that these terms that you're sort of loosely understanding in this chapter will be reinforced in a deep way, and that you will walk away from the course having a really good understanding of what a contract is, and that will help you in all of your business decisions. It will help you in hiring people. It will help you in negotiating commercial transactions as well.